those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Please be seated. Good morning. We have four cases on the queue today. Gratified to get such a large audience for that. Welcome, everybody. With me is Judge Murphy from Utah, Judge Bacharach from Oklahoma for today's arguments. But before we start our oral argument, we have a preliminary matter.
Thank you, Your Honor. I'm before you this morning with a preliminary motion to admit 2 new members to the bar of our court. Before making the motion, with your permission, I'll introduce the candidates.
You may proceed.
Our candidates for admission, please approach the lectern. Our candidates for admission this morning are Phil Kim, one of Judge Murphy's law clerks, a graduate of the Georgetown University Law Center and a member of the New York Bar, and Eugene Jiang, one of Judge Bacharach's law clerks, a graduate of Harvard Law School and a member of the California Bar. Before I make the motion and administer the oath, are there any questions or comments from the bench?
Judge Bacharach, any questions?
Well, I have an editorial comment. It's just such a pleasure and an honor to work with Eugene, who I think is just an extraordinary scholar and, more importantly, an extraordinary person. And Mr. Ken, you couldn't have found a better mentor. It's the same mentor I have, a generation or two apart, but I know you will have a wonderful, successful, and happy career.
Judge Murphy?
Mr. Kim, Phil, is one of the most delightful people I've ever met. And it's a little bit out of order. I'd like to recognize his family and his partner, if they'd stand. All right, they don't follow. They're kind of like Phil. Phil, they don't do what I say. So, I told Phil to prepare to respond to a question regarding the rule in Shelley's case.
Oh, gosh.
But knowing Phil, I'm sure he prepared. So, I was thinking about going into the rule against perpetuities.
Oh, gosh. Wow.
You remember the life and being and?
Yeah, of course.
Okay, all right. Anyway, proceed.
I respectfully move for the admission of these candidates to the bar of the United States Court of Appeals for the 10th Circuit. May I administer the oath?
Please.
Please raise your right hands and repeat after me. I do solemnly swear
I do solemnly swear
that I will conduct myself
that I will conduct myself
as an attorney and counselor of this court
as an attorney and counselor of this court,
uprightly and according to law,
uprightly and according to law,
and that I will support the Constitution of the United States.
and that I will support the Constitution of the United States.
Congratulations.
Thank you so much.
Congratulations, thank you. And you'll get a bill for your bar admissions now.
Thank you.
We'll look forward.
Thank you.
Okay, let's get started with our first case, which is 25-1159 Holt versus Florissant Fire Protection District. Mr. Block?
Raise this up a little bit. Good morning, Your Honors, and may it please the court. My name is Grady Block. I'm with Mountain States Legal Foundation, and I'm here to represent Mr. Eric Holt, who's here with us today. Respectfully, this is a little ambitious, but I'd like to try to reserve 4 minutes for rebuttal.
I'll try to help you.
All right, thank you, Your Honor. So we are here today because Mr. Holt was fired from his job as the fire chief of the Florissant Fire Protection District in retaliation for speaking out in the course of a criminal investigation regarding an election that happened with the board for that fire protection district. The entire board was replaced, just as a little bit of background, and there was quite a bit of drama that happened along with that transition. In the course of that investigation, Mr. Holt was approached by an investigator from the district attorney's office who asked him for footage and several questions about, what was happening that day and what was shown in the footage. Mr. Holt was enthusiastic in responding to that request. He went out of his way, went to a third-party company called Upworks to go get the footage, since they didn't actually manage the footage in-house. It was outsourced to a third party. He went and got that footage. He met with the investigator, Mr. Kramer, and answered a lot of questions, specifically identifying who was where, the distances between things, questions that matter for elections, right? You know, there are certain regulations on how far people can be to the polls, things like that. So he was helping assist and answer those questions. He was helping provide detailed answers on what happened that day. Specifically, he actually received 2 complaints from citizens on the day of the election, since he happened to be at the firehouse, purely for an unrelated matter. He had nothing to do with the election, of course. He's a fire chief.
Is it customary to have have the fire station as a polling place for local elections?
I'm not sure, Your Honor. I think it kind of makes sense. It's fitting for the fire protection district itself, but I'm not sure if that's customary, to be perfectly frank with you. What is important, though, is he happened to be there that day responding to something that is absolutely within the course of his job duties. He was there to respond to an incident, a medical incident specifically. That's what he says in this deposition. He had nothing to do with the election. The party, or the district, actually appointed a designated election official to oversee the elections. They had poll watchers, full-blown election, right? So the court below correctly applied the Garcetti-Pickering framework to this case, but improperly decided.
Let me ask you a factual question. In the inquiries that were made of him by the district attorney, were they logistical things about who was where, near the polls and things like that?
Some of it was, Your Honor. So he did relay information, you know, who was where in the fire station and how far they would be to his knowledge, you know, because he's the best person to answer that, frankly. Part of it was logistical and distances, things like that, but part of it was also relaying the citizen complaints that he received on the day of the election. So it was twofold, really, well, threefold. So one was providing the video itself. Second, he was answering those logistical questions. And then third, he was also relaying his own complaints that he had received from citizens.
And the complaints were?
That people were talking to voters within that threshold, you know, trying to get them to vote certain ways, things like that.
Was the video not fully expletive of who was where in the voting area?
I'm not sure, Your Honor. I haven't seen the video myself, to be perfectly honest with you. But it was helpful, obviously, to have somebody there that's intimately familiar with the fire station that can tell you how far things were and specifically identifying who people were as well. So it was several different categories of facts that he was rolling into that.
Is he ultimately responsible for managing the fire station?
Yes.
I assume that he or somebody on his staff let the election workers in the morning and let them, excuse them at night and locked up or cleaned up after them?
Sure. So he is responsible for overseeing the fire station pretty much in its entirety. He's the only person that's a full-time employee there. He answers specifically to the board. But they don't actually manage the security system that had the footage. That was managed by a third-party vendor.
Yeah, well, yeah. So you should move to whether what he did was within those official duties or not under Garcetti. You know, I want to, you know, hear the, you know, your response to the Florissant's argument on that.
Absolutely, Your Honor. I would love to. So in Lane v. Franks, one of the critical questions that the Supreme Court talked about there is we look at the ordinary job duties of what that employee is charged with and doing. As a firefighter, he's charged with responding to fire incidents, responding as an EMS, managing employees and volunteers, things like that. He has nothing to do with elections, investigations, criminal investigations, anything like that. And another case on that as well is Tufaro v. Oklahoma Board of Regents. That case was just cited by this court in the Timmons case just a couple months ago. In that case, the court said specifically we look at the type of activities they were paid to do. And again, as a firefighter, he has nothing to do with elections investigations. Managing the firehouse, absolutely. But yes, sir.
Can I ask also a factual question? Now, I understand that that monitoring the video was outsourced, but the chief also, he did utilize, as I understand it, the digital surveillance system in order to give access to new employees. And I really wasn't quite sure factually what that meant. So is it, I'll ask it this way, is it a fair inference that as the fire chief, he did have control over that surveillance system, albeit for a different purpose, but it's the same digital system that underlay the entire investigation.
Sure. So as I understand it, the access system had a couple different components to it. For one, as I understand it, they used it partially as access to the building. It had a function that essentially operated like a key. So part of the login information was for that as well. But yes, it did have the ability to access the cameras, but not necessarily the footage. So he wouldn't be able to pull up past footage, as I'm aware of it. You could access live footage, things like that, but he had to go actually to that third party to get previous footage. So you wouldn't really be able to get it in the same kind of way. But again, moving to
Wait, a little more on the facts.
Sure.
The expression employees and staff have been used. What employees and staff were there besides Mr. Holt?
So he was the only full-time employee. They did have a number of volunteers that worked there as well. And then I believe a couple part-time employees, one of which was also terminated by the board immediately following the election.
Part-time on the payroll?
Yes, Your Honor, I believe so. But not full-time, so.
All right. Is there anything in the record that indicates why he didn't dispatch the part-time employees to get the video?
No, Your Honor, I don't think so. I think it was mostly just because he was enthusiastic about helping out and making sure that government accountability was there and present. He wanted to make sure that his new board was operating with integrity, especially in light of what their job was to do.
So in terms of that perspective he had, he was the only one who could get the video from the security company to give to the district attorney, correct?
I think that's probably correct, Your Honor, but I think the district attorney could have also gone straight to the company as well. I don't think that would have been an issue.
District attorney is not an employee of the fire district, though, right?
Sure,
And the
that's true.
contract, I'm assuming, the record indicates the contract was with the fire district.
That's true, Your Honor. But again, this is another interesting part of this case is this is the only the second time he had ever talked to a criminal investigator in the course of his multi-decade career. This is not something that comes up ever in his job duties, really. This is very, very unrelated to being a fire chief. So it's...
If there'd been a theft in the fire station, would it be part of his official duties to cooperate with an investigation into that?
I think so, probably, Your Honor. The difference is there, it's still not necessarily part of his job duties as managing a fire station, and it certainly wouldn't be relevant for a First Amendment retaliation context because we still have the other 4 factors under Garcetti we would have to look at. So it could be in that case, but for this, I don't think so, because he was speaking out on a matter of public concern specifically for accountability for this potential wrongdoing. He wanted to make sure that those new officials were operating with integrity. So it's a little bit different than just a routine kind of something was stolen here, I'm in charge of the stuff here, I need to go report it. This is a totally separate matter from managing the firehouse. So, but again, our court's history has said that repeatedly as well. You look at the type of activities he was paid to do, and this isn't something that he would be paid to do. He's paid to respond to fires and manage EMS, things like that. And the fact that it comes up only twice in the course of his long career as a firefighter, talking to a criminal investigator, that's telling, I believe, Your Honor. And specifically, that first time he talked to an investigator, he was responding in the course of his duties that time. He responded as EMS to a shooting incident and was relaying information about that, which that one absolutely would be part of his job duties. This is unrelated to his job duties. And because of that, it makes it private speech and not official duties speech. With that, I think...
Refresh my memory on this, on the facts. There's part of the new regime involved somebody named Schultz,
Yes, Your Honor, that's correct.
and there was something about him, Holt, being named at a party.
Yes, Your Honor. So there was a separate complaint filed by one of the outgoing board members, Starla Thompson, who filed her own separate complaint from this case. And in that response, she named him as a defendant, him being Schultz. And then Schultz, in his response to the complaint, said that Holt had improperly or illegally put in these camera systems and asked for the court in that case to press charges against him for that. So that's how he got brought into that case. But he was never a party in that case.
And
or
didn't
anything
he
like that.
disclaim all involvement?
He disclaimed that he wasn't part of the case, so he didn't really need to know about the case.
How does all this play into the issues we have to resolve, if at all? Maybe it's irrelevant.
Sure, and I think that's probably true, Your Honor. I think that comes into whether he was pretextually fired. I'm sure you're aware of the insurance
Oh,
lapse
okay, okay.
situation.
That's
So I
the
think,
other issue.
right, yes, Your Honor. So I think that goes to prongs 4 and 5 of the Garcetti analysis, and the district court halted their analysis solely on prong 1, which is whether it's within his official duties. And as a part of that, I don't think this court needs to reach those issues if you don't want to. Again, in the Timmons case, y'all just said that the normal favorable course is to resolve what's directly on appeal and then just remand for the rest. And I think that would be perfectly appropriate here, especially where there's factual contentions and on a motion for summary judgment posture. And with that, I am a little bit past where I tried to reserve, so I will save the rest of my time. Thank you.
Let's hear from Florissant, Ms. Cook.
Good morning, Your Honors. May it please the court, I'm Sarah Cook on behalf of the Florissant Fire Protection District, here to request that this court affirm the district court's grant of summary judgment in this case. The district court did hold that the first element of the Garcetti-Pickering analysis was dispositive and thus did not reach the other 4 prongs. In Garcetti, the Supreme Court declined to articulate a formula for determining when a government employee speaks pursuant to his official duties. It's a case-by-case analysis, which the district court performed in this case based on the record before it. A speech can be pursuant to an employee's official duties, even when it concerns an unusual aspect of an employee's job that is not part of his everyday functions.
Can I ask you a hypothetical question? So I work in a government building with video surveillance. I have nothing to do with that video surveillance. If there was a comparable situation, let's say there was an election in my courthouse, and let's say a law enforcement officer asked me to get that footage of the video, would that be within my job responsibilities since I work in a building with that video surveillance? And let's say hypothetically, I'm the only employee in that government building. Is that a part of my job responsibilities because I work there?
And in this hypothetical, I'm assuming you have access to the video footage.
No, just like the chief doesn't.
Well,
According to the evidence that he's presented, viewing the evidence in the light most favorable to the non-movement.
sure. I mean, I think in this case, Chief Holt did have access to the video footage, but it was the stored footage.
Okay, let's say, good point. So let's say they ask me, the law enforcement officer says, give me a thumb drive of that, so that he or she can view that footage rather than coming into the marshal's private arena to look at past footage. Would that be part of my job responsibilities?
I think yes. As an officer of the court, you would be expected to comply with a law enforcement request. I think, taking it a step farther, if you refused, I think that would also be okay. I don't
Well,
think.
how can both of those things be true? If I can refuse, then it's not part of my job responsibilities. It may be something that I, as a good citizen, should do, but how can you say both that it's part of my job responsibilities and that I have the opportunity, the right to refuse? Are those not mutually exclusive?
I think the term job responsibilities is what is problematic in that hypothetical. So I would not say it was part of your job responsibilities, but if you did provide it, I would say it was pursuant to your role as a public employee. And I think that is, what the cases have held.
What about Timmons? Isn't Timmons directly inconsistent with that?
Your Honor,
Just
I'm
because
not,
I'm sorry.
sorry, I'm not familiar with that case,
Okay.
actually. I didn't realize I didn't see it cited
Oh,
in
Timmons,
this
I was
case.
referring to, maybe you're thinking of it as Plotkin, Timmons versus Plotkin? And if not, don't worry about it.
Yeah, I'm sorry, I'm
That's
not
okay.
familiar with that
That's
case.
okay.
But in other cases, like Green versus Board of County Commissioners, where the employee was a drug lab technician for some sort of juvenile detention facility, and she was concerned that she was getting a lot of false positives. She took her concerns to her supervisors. They didn't seem to care. And so she took it upon herself to go outside and find a company to, verify whether the drug tests were in fact accurate. And the court, in that case, held that that conduct, that speech, was pursuant to her official duties because it was generally consistent with the type of activities she was paid to do. And here, Chief Holt admits he was in charge of the fire station. He was the fire chief, chief executive officer of the Florissant Fire Protection District. And
Doesn't the fact that he did it out, in his spare time effectively, he used his own money to secure some of the footage, doesn't that point towards more private conduct or private speech than part of his official duties? Why would he do that if it was part of his job function?
sure, I think first, Your Honor, that those facts are not part of the record. Those facts were just raised for the first time in Mr. Holt's appellate briefing. At least my review of the record did not contain those facts. But even if that was true, as fire chief, he was technically always on duty 24/7. This is a very small fire protection district, and so even if maybe he wasn't technically scheduled for that day or whenever he went and got the video footage, I think that just doesn't matter for purposes of the analysis.
So your position is that this business about him using his own resources was merely assertions in the pro se briefing that was filed by Mr. Holt, and there is nowhere in the record that verifies those as being supported by evidence?
That is correct,
Thank you.
yes. And that, this case, it was the district court reviewing the record and making the decision on the basis of the record in front of her. And that is, and based on the facts in the record is what led her to determine that this was part of Chief Holt's job as a public employee. And, something else with regard to, he got the footage. He never told the district attorney, I want to complain about election fraud or election violations. That was, never that's not a part of the record. When I took Mr. Holt's deposition, I asked him all about his conversation with the district attorney, and it was limited to the district attorney asking him, how far away is this person from this person? Maybe, what is this person's name? And Chief Holt answering those types of questions.
Is the deposition transcript in the record?
Part of it is, Your Honor, not the entire thing.
If I were to get my hands on the entirety of the transcript, would it disclose that you asked him very general questions such as, what did you do? What did you do then? What did you do next? That type of inquiry?
Well, with regard to his conversation with the district attorney,
No,
Okay.
I'm directing it more about his use of his own resources in acquiring the video.
that never came up. I did not ask that
Were
question.
your questions open-ended enough that it should have come up if it happened?
I mean, my deposition practice is to always, seek out as much information as I can. With regard to how he obtained the video footage, I just remember that as being, the district attorney called him, said, "Can you provide me with the footage?" And he testified that he answered yes, because this is a law enforcement officer, so he's going to do what he says. And then he just went out and got the footage. Nowhere, I mean, he never said that he used his own money to maybe buy the thumb drive. Yeah, that was never brought up in deposition.
How would you distinguish Lane versus Frank, which is one of their primary cases?
Yes, Your Honor. I mean, Lane versus Frank's was obviously a holding about sworn in-court testimony. We don't have that. I mean, we really don't even have testimony here. We have him, Mr. Holt, answering questions about some video footage. And that's how I would distinguish Lane versus Frank's, is that the holding, was with regard to when a public employee provides in-court sworn testimony.
Do you think if he'd been subpoenaed in this case, his in-court testimony would not be pursuant to his official duties?
If he had been subpoenaed in the, say the district attorney brought
Yeah,
election fraud charges against the board,
yeah, assume that.
and his testimony was limited to, hey, this is this person's name, this is how far away this person was from this person. I think according to, and then if some adverse employment action had been taken because he provided that in-court testimony, yes, I think Lane versus Franks would be persuasive to say that his testimony was private citizen speech and protected by the First Amendment.
Can I ask you a somewhat general question about the intersection between the summary judgment standard and our case law that everyone agrees treats prong one of Garcetti-Pickering as a question of law? To apply that question of law, do you agree that we do have to view not only the evidence, but all the reasonable inferences from the summary judgment evidence in the light most favorable to Chief Holt?
Yes, Your Honor.
Okay, that's all I wanted to ask.
And even if the court were to hold that the first element of the Garcetti-Pickering analysis went in favor of Mr. Holt, this court could still affirm summary judgment on a different basis, specifically that there is no evidence of retaliatory intent, and that the district would have terminated Mr. Holt even in the absence of his interaction with the district attorney's investigator.
Well, how do you, you go ahead, Judge.
And that reason was because he let the insurance lapse?
Yes, Your Honor.
Doesn't the record indicate that he had no authority to pay for the extension of the insurance? And then, in fact, nobody had authority because the bank was not recognizing the new board's ability to sign checks?
So with regard to that issue, yes, Mr. Holt could not have just written a check for the $20-some thousand that was the insurance bill. But
Then include in your answer, why is that not good evidence of pretext? He got fired for something that he was supposed to do that he had no ability to do.
right, but the problem is he, as fire chief, he should have presented a check to the board for signature. or he should have said, hey, this thing is due, we need to get this paid.
What about the April 30th email that had in the subject line, June 1st, where he circulated the invoice from the insurance company to Mr. Del Toro, the new president of the board?
Right, and I think that was actually a May 30th email from Mr. Holt.
Prior to the deadline.
Sure, and they actually had a conversation also on May 30th. And the conversation was limited to getting Mr. Del Toro to sign the uninsured waiver. Never was the fact that the insurance invoice had not been paid brought up. The invoice had been issued, I believe, like first, maybe in April. And so Mr. Del Toro assumed it had been paid.
The email that Judge Bacharach asked about, was that sent before the expiration of the insurance and the grace period?
It was sent, I believe, May 30th, and the insurance lapsed June 1st. So apparently there was no grace period.
The new board president was aware before the expiration that there was a need to pay the insurance.
He was not. He was not aware. It was his reasonable assumption that it had already been paid as the invoice was.
And a question of fact, whether that was a reasonable assumption?
I mean, possibly that would be a question of fact, yes. But there were, a lot of other parts to the investigation that led the board to a unanimous vote to terminate Mr. Holt on that basis.
All right, I think your time's expired.
Thank you.
We have some rebuttal time left for Mr. Block.
Mr. Block, let me ask you initially, I know this is a little awkward for you because you didn't do any of the briefing. It was all done by your client. But we have a record problem here. What do you say to Ms. Cook's statement that there is nothing in the record regarding his use of his own resources to get the thumb drive?
Sure, Your Honor. So on my review of the record, I also did not see anything about him personally paying for it, to be honest.
Okay, so there's nothing in the record.
Not regarding him paying for it. There is evidence from his deposition that are in the cuts that were made for the summary judgment briefing that says that he had to go to the vendor to pick up the thumb drive with the footage on it. And, well, he took the thumb drive, but he had to go get the footage himself. So that is in the record, but personally paying for it with his own funds, that is not in the record.
What about the Ms. Cook's assertions about the statements he made to the district attorney?
Sure, so there's...
The record?
Yes, Your Honor. There's evidence from his deposition that shows he was talking about what kinds of questions he was answering in that deposition that she took. So that is in there, Your Honor.
But Ms. Cook properly stated the status of the record.
Regarding the first point about him paying out of his own pocket, that's accurately stated. In volume 2 on page 80, oh, sorry, that's the wrong site here. In his deposition on page 57 and 58, it specifically says he was relaying citizen complaints as well. So it was more than just the logistical questions, who was where, who is this. So that is in the deposition, Your Honor. But to Your Honor's questions, I think the amount of factual questions we have on appellate review leads a lot of credence to the idea that this was not a case subject for dismissal at a summary judgment stage.
What factual questions are you talking about regarding the first issue, and that is whether he was acting as an employee or a private citizen? What are the factual questions?
So there's not as many on that prong, Your Honor. Frankly, I was more talking about the remaining factors under Garcetti.
I understand. So answer my question on that prong.
Sure. So on that prong, Judge Wong did say he was acting in his official capacity on the day of the election, and then seemingly uses that to say he was acting in his official capacity for the rest of it. But he was there that day specifically solely to respond to an incident, and that's when he received the information. And Lane v. Frank specifically says merely acquiring the information in the course of your employment does not automatically render that speech into employee speech rather than private citizen speech.
That's a question of law, not fact, right?
Correct, Your Honor. But beyond that, to Judge Bacharach, your question about the judge asking for footage or providing footage, that's interesting that you bring that up, because there actually is a case that the appellees brought up specifically in their briefing, the Aquilina case, and they do a fantastic job describing what the district court did in that case. But on appeal, the Sixth Circuit actually reversed them and said a judge providing footage to the press, specifically in that case, actually was private speech, even though that footage happened in their courtroom. So to your question, that hypothetical has borderline been addressed by the Sixth Circuit, and they found that it was private speech, not public speech. To your point as well, Mr. Holt could have refused. There was nothing compelling him to provide this outside of wanting to make sure there was government accountability. With that.
Yeah, your time's expired.
Oh, I'm so sorry.
Thank you very much.
Thank you.
Your excuse in the case will be submitted. A big fan club for that case. Could somebody grab the door in the back, please? Okay, let's turn to number 2, 25-1211, Joyner versus Frontier Airlines. Mr. Ward for the appellant.
Good morning, may it please the court. Christopher Ward on behalf of Appellants, Menzies Aviation, and Frontier Airlines. My hope is to have about 3 minutes for rebuttal. We'll see how that goes. Your Honors, I submit that the most significant question for this court to resolve it is not whether to reverse, but what to do with an order to reverse, considering the degree of error that the district court committed here in its misapplication of the Saxon framework and its failure to follow that analysis. Now, the district court explicitly indicated that it was going to look at that first step by focusing on plaintiffs. And that's in fact what it did, and that's what it did in the order. And that's legal error. Right, and to date, the district court is, as far as I can tell, the only court that has done Saxon's first step analysis in this way. And equally erroneous was the district court's decision to find that these plaintiffs, and you look at the order, he refers regularly to these plaintiffs as opposed to the class of workers. But it was erroneous to find that these plaintiffs are transportation workers without any consideration for how frequently they are performing what might be qualifying as transportation worker duties. Instead, the district court to these concepts of gatekeeping and overseeing and being enmeshed in a much larger transportation system. And that's how the district court found Saxon's second step satisfied. Your Honor, please.
How do you deal with Brock versus the Brock case? Because in Brock, as I understand it, the last leg driver never transported anything in interstate commerce. And we still concluded as a matter of law that they were transportation workers.
Correct, Your Honor. And quite frankly, I don't think the Brock case is on point in this all. We're not arguing the interstate, intrastate dichotomy in this case. And that's really what Brock boils down to. In Brock, The class of workers analysis, which is the first step of the Sachs analysis, wasn't in dispute. How the district court and how this court defined the class of workers clearly focused on the actual class. And our point here is the district court didn't focus on the class of workers. It focused on the plaintiffs.
Well, let's say we conducted an over review and we say, well, the last leg drivers in Brock were part of a single uninterrupted chain of events that resulted in the transportation of goods interstate. Those drivers didn't necessarily transport anything interstate, much like the CSA workers, let's say the ticket agents, hypothetically, may not have actually transported goods or even held goods, but that they were part, the argument would be, that Menzies and Frontier make, is that they would, in essence, be part of that single unbroken chain, much like the last leg drivers in Brock. That's my question.
I understand the question, Your Honor, and I think there's two distinctions there. One is, again, in Brock, the class of workers were in fact transporting things, right? There's no dispute that they were actually the ones transporting the goods. And the question at that court and what's before the Supreme Court right now is, what does it mean to be sort of the last mile transporter? Is that sufficient? Again, the district court here didn't find that they were transporting goods. What the district court found here was that they were enmeshed in a transportation system. They were gatekeepers to passengers transporting their own goods. They were overseeing other people doing the actual transportation. And if you read Circuit City, Saxon, and Bissonnette together, you get a very clear statement of what a transportation worker is, in my view. Circuit City says this is a narrow exemption. Saxon says, here's how you resolve it. You define the class of workers. Once you know what that class of workers is, and again, you focus on the class, not the plaintiffs. You focus on the class. And once you've done those things, then you decide, are they engaged in interstate transportation or not? And Bissonnette says it's not an industry-based analysis. It is what do the class of workers themselves do. And I submit to the court here that the district court is saying this class of workers, or in fact these plaintiffs, because that's what the district court did, they don't transport anything. They lift, they weigh, they help passengers, but primarily their job is customer service. And they work with an infrastructure where conveyors transport the baggage or passengers transport the baggage.
Aren't these plaintiffs, though, exemplary of the work that all customer service agents do? I mean, maybe the district court erred by focusing on the plaintiffs, but the work they do is work that is generally done by every employee that is up at the ticket counters, right?
And respectfully, Your Honor, I disagree. The district court flat out told us during the evidentiary hearing he wasn't interested in evidence about the other workers. And this is on, volume 2 of the record, pages 425 to...
We have the Menzies job description.
And
right? Doesn't that tell most of the story?
And then I guess I would say, yes, the job description is useful. And you've got a number of cases we've cited in our brief that say job descriptions are useful, but the inquiry needs to go beyond that. Because job descriptions are intentionally sort of vague. And, you don't know for sure what every single person is going to do. And so we attempted to introduce evidence, and there is evidence in the record. There's objective evidence in the record, video footage of CSAs never touching a bag. Right, there is objective evidence in the record that shows what they are actually doing. And then we did submit the testimony of somebody who trains these workers. Tricia Moreno testified at the hearing, and she trains this classification of workers. She supervises this classification of workers, and she testified that what the plaintiffs said about their job is incredibly hyperbolic. And if you read my cross-examination of the plaintiffs, they went from exaggerating how much they were working with baggage from, this is all we do. It's 100% of every shift, every day. And I said, no, let's get granular. I want numbers. And you read their cross-examination, and all day, every day, finally became something like, it's a handful of passengers out of every hour, and I see at least 100 passengers every hour.
Mr. Ward, is it the defendant's position that if the evidence were that these customer service agents seldom or never touch the bags. Is it your position, is it they have to at least touch the bags and move them to be a transportation worker?
I think that's an easy way to understand the Saxon analysis. I don't know that that is exactly how a court would apply Saxon.
I'm asking the position of the defendants.
Our position in this case, Your Honor, based on this record, is that,
I'm asking a hypothetical.
sure, I don't,
That is, do you say they have to touch the bags regularly?
the answer is no, Your Honor. That is not our position. Our position is they have to transport them. And I understand that maybe.
If you have a CSA agent, let's take the ones at the carousel or that are dealing firsthand with the flyer. Is that enough that they tell them what to do? Here's how you tag your bag. You know, you need to lift it up and set it there. Here's your boarding pass. Is that insufficient as a matter of law, in your view, to be a transportation worker?
Yes, it is, Your Honor. That is our position.
What do you do with the view in Saxon that said, and this is a quote, that they have a role in the flow of goods? Don't they have a role in the flow of goods, even if they generally don't?
And in Saxon, the role that class.
I'm talking about Saxon talking broadly in its statement that it's a question of what role they had in the flow of goods.
And I think it is important to look at Saxon as a whole, because the role in that case was ramp agent supervisors who spent a sufficient amount of their working time actually taking baggage and loading it onto an aircraft. And then if you look at the footnote in Saxon where they say, we're not deciding the question about whether supervisors are transportation workers, but we acknowledge even that one step of removal, I am watching you do your job, that may be a different question. And so I think if you look at Saxon just at that level and you apply Circuit City to it, which says this is a narrow exemption, a transportation worker has to actually transport the goods in some meaningful fashion.
So you're saying they have to actually touch them on a regular basis?
Not necessarily touch them, because I could give you the exemption of a truck driver who did not load the goods, but transported them across state lines. I would say that person is transporting the goods, notwithstanding the fact that they did not actually load them onto the truck. But they are still, in fact, directly transporting things. Here,
Would the workers that loaded the cargo on the truck be entitled to the exemption?
I think that is the ramp agent case, Your Honor. That's the Saxon case.
Right. And, are you saying that there's a frequency? I think it's a variation of what we've been discussing. Is there a frequency component to Saxon step?
There absolutely is. It's written into Saxon. We cited.
It was written into Saxon because it was undisputed that the ramp loaders frequently loaded goods onto and off of the plane. So it was certainly sufficient. And so, as you pointed out, it would be a more difficult case in Saxon if it weren't the case. But how could you say that this is an undisputed fact in Saxon, and therefore it becomes, I mean, it's illogical to say that that is a requirement in every case just because that happened to be the undisputed fact in Saxon.
Agreed, Your Honor, but that is the word Saxon used. And there are multiple courts that have taken Saxon's language and applied a frequency analysis.
Other than Fraga 1?
Fraga is one. There's multiple district courts that we cited about it as well. They're in our briefing. Actually, there's one that neither party cited that I came across as we were preparing for. It's the Wilson versus Get It Now case. It's 2025 Westlaw 2304686. It's a District of Minnesota case from August of last year. I just realized this morning that's actually the same firm representing the plaintiffs here. We're representing the plaintiffs in that case. And I think the district court's analysis in that case is very fulsome. It looks at the class of workers. It looks at the frequency analysis. It looks at the burden of proof and ultimately decides a district manager in that case who essentially says, I control the transportation process. The district court said that's not transportation if you control it.
What if it's, let's say the year 25 years from now, and the CSA doesn't load, doesn't do anything with the luggage other than put it on the conveyor belt. And then the CSA tells operates the conveyor belt and says, take that conveyor belt, this long conveyor belt, from Denver to Oklahoma City. There's no planes involved. They don't touch the bags. Are those CSA's transportation workers?
I submit that they are not, Your Honor. They're not transporting the baggage. The machinery is.
They're operating the machinery. They're saying, hit the button, go.
How far would that go then, Your Honor, is my question.
Well, okay, I mean, I guess we could both ask each other hypotheticals, but my hypothetical is, isn't that the problem with your argument, is that in response to Judge Murphy, whether or not they touch the bags, they 100% of the time, at least those ticket agents, are operating that conveyor belt. And whether or not they're physically touching the bags, it's hitting the button to that conveyor belt that allows that bag to somehow end up on that plane.
And I appreciate the hypothetical. My position is no, they're not transportation workers. And it's not just me saying.
They touch the bag as opposed to moving the bag through machinery?
Because Circuit City says this is narrow. Saxon outlines for us how we apply this. And then Bissonnette says this is very focused and we need to avoid industry. And I think that's part of the argument that the district court applied here is by saying they're enmeshed in the process. They're gatekeepers of other passengers doing it, not themselves, other passengers doing it. They are overseeing what other people do. On some level, everybody who works in this industry is a gatekeeper. Everybody who works in this industry in some fashion or other is overseeing the process. But this is a narrow exemption, and the Supreme Court has told us it is not based on what the employer does. It's based on what the class of workers does. And what the class of workers does here is customer service.
I will give you some rebuttal time, but why isn't the fact that at least some of the CSAs move bags, from the customer to the conveyor belt, why isn't that close enough to what the ramp people did in Saxon to entitle them to really the same analysis?
And I think that goes back to the frequency question, Your Honors. Okay, occasionally, and the record is clear on this, occasionally these CSAs will assist a passenger. If they're not physically strong enough to move the bags, they will do it. But that is why I went to great lengths during the hearing to develop, all right, how often are you doing that? Right, because it matters. It matters under the Sachs analysis. And again, the plaintiffs were very hyperbolic in their testimony, but they were very imprecise. And I forced them to get precise. And when they got precise with numbers and time, it became far less than, the Fraga cases used a 25%. We're talking about 2 to 3% of their time they're doing this stuff. And so if you apply frequency there, that's why it's not sufficient.
All right, thank you. Of course.
I'm sorry to ask you this question, but I am really curious about it. You probably sat in on the last argument, and we have a fire chief. And let's say the fire chief is on the job for 5 years, and there has never been a fire in his or her community. Is putting out fires an integral part of the fire chief's responsibilities, even though he has never put out a fire analogously to these CSA agents that hypothetically have never touched a bag?
I agree with you, Your Honor. That is part of the job. But Saxon tells us to look at what the class of workers actually does, not what they are hypothetically engaged to do, but what they actually do.
Then why is putting out fires an integral part of the fire chief's responsibility if he's never put out a fire?
Because I mean, I'm getting sort of far afield of my own hypotheticals here, Your Honor, but that is the nature of the job, is to be available in that
when needed.
When needed.
And so if somebody comes in with a 90-pound bag, let's say at the gate, and maybe that just never happens, but that's why the agent is at the gate to make sure that someone doesn't take on extra large baggage, even if it never happens, right?
I would agree, Your Honor, and that's why the frequency analysis matters again. If 50% of their time they're doing this, then Saxon says that's a transportation worker. And the ramp agent in that case was a supervisor. I think the evidence was at least 2 to 3 days of their 5-day week, they were loading bags, right? That's not what the record evidence is here. And that's why the frequency analysis, which the district court didn't conduct, even though this was a clearly disputed issue, that's why I think this is error there, and it matters, really important to this case. Thank you for the questions, Your Honor.
Thank you.
Thank you, counsel. Ms. Wood?
Good morning. I'm Shelby Woods, counsel for Appellants, and may it please the court. 3 points demonstrate why the district court correctly found that CSAs are transportation workers exempt from mandatory arbitration. First is the standard of review. Now, the district court held a full evidentiary hearing. Appellants are unhappy with the findings made as a result of the evidence they chose to present, rather than presenting evidence on the actual work that either the ticketing and check-in CSAs perform or the gate CSAs perform. They tried to present evidence of expectations, of training, of system design, intention.
Are you saying that evidence was irrelevant and should not have been received?
No, Your Honor. What I'm saying is it is only relevant to the extent they can establish that those expectations, that supervision, that design actually coincides with the actual work performed. That is the first step of the Saxon analysis.
I thought they tried to put on evidence of actual frequency, and it was either rejected or not considered in the opinion. Am I correct?
No, Your Honor. 2 points there. They did not attempt to put on evidence of actual frequency, but tried to make the conclusion of frequency based on those expectations, based on those sort of more abstract arguments of what they claim the system was intended to, how it was intended to work if everything worked perfectly.
You're telling me if I go to the record, there is no evidence whatsoever as to the frequency of the handling of bags by CSAs generally?
There is evidence of how CSAs purportedly handle certainly luggage, cargo, and also passengers. There's actually an extensive examination on that. And the only part, I think, that is taken out of context by appellants that Judge Cruz did say was when appellants were trying to present evidence, or actually right after, I believe appellants had said, you can't look just at the job descriptions here. Yes, the job descriptions say that CSAs are expected to frequently lift cargo up to 70 pounds. You can't just look at that. That's looking at every scenario. You have to look at everything in context.
So are you telling me there is evidence of the frequency generally of this class of CSAs at the carousel and at the gate?
Yes, Your Honor.
right.
There is evidence of frequency where if the court wants to make a ruling just simply on the fact that someone physically lifting, physically manipulating, hauling, pulling, pushing, all of those things that actually result in conveying the cargo to the next point in the stream of commerce, it can make a finding just simply on that and not actually consider whether these other instances of maintaining control, maybe through verbal instruction, through visual control, whether those would be independently sufficient to find that these are transportation workers. But even just giving credit to this argument that the finding of fact of frequency in Saxon, that actually creates some kind of implied test where courts are required to at least consider some type of quantifiable frequency, which I think is assistive, certainly, in determining whether we have transportation workers.
On the actual activities of these three plaintiffs, was Mr. Ward correct in his characterization that when he was examining them, is it suddenly the frequency with which they put bags on the carousel significantly diminished?
No, Your Honor, because that
So
free.
he did not properly characterize the answers on his examination? of those-
I do not believe that it would be accurate to say certainly that there was a contradiction as far as the frequency that would cause the court to, legitimately
Well,
believe
wait
that
minute.
there was
My
a credibility
question
issue
is-
there.
My question is, Mr. Ward said that upon his examination, that their testimony indicated in actuality, it was not very frequently that they actually handled the bags physically. Is that incorrect, what he said?
That is incorrect, Your Honor, and thank you for restating that. I do understand what you're asking. He attempted to, extensively cross-examine all three plaintiffs and try to create some inconsistencies, and that actually shows the limitations of a really specific, strict frequency analysis, because these are roles that are just so intimately involved with transportation, that it's so enmeshed that it becomes an exercise of really futility, where you almost start distorting little aspects of the job and start to lose the big picture of, we're dealing with workers who, if you imagine the ticketing, the gate desks at a major international airport like Denver International Airport is just completely empty, transportation does not happen anymore. There aren't passengers getting through. There aren't passengers with their luggage getting through. To say that this is all something like...
Say that again, because I didn't really follow that. I mean, yeah, explain that.
So certainly, Your Honor, this is all the big picture context for whether these are a class of workers that would be considered subject to Section 1's exemption, such that they should not be tied up in the FAA if there were to be a dispute that, for instance, would cause all CSAs to just simply walk out of the job. If that happened, would that result in a direct impact to international or interstate transportation? And here it absolutely would.
Wait a minute, you're confusing me too. I thought what we look at is the actual evidence of the frequency with which CSAs physically handle baggage. Isn't that what we're looking at?
We absolutely
We're
do,
not
Your
worried
Honor.
about, oh, well, if they get fired or they get...
I completely agree with you. Really just envisioning what the overall role of this class of workers is to the transportation system is just a cross-check that you do when you're actually evaluating what the actual work is that's being performed. Because the whole part of the Saxon analysis is to determine whether that role, whether that class of workers has a direct and necessary link with international or interstate transportation.
Wouldn't you say that it would appear from Saxon that if the supervisor had the evidence was she had seldom handled baggage physically, that the outcome would have been different?
Likely not, Your Honor, because it still would be such a direct link to the actual transport of that cargo that really, whether she is supervising it and controlling in that fashion or directly physically handling it herself, the distinction really doesn't serve a significant difference as far as determining whether
Wait a
this is
minute,
someone who's inactive.
You're suggesting that Saxon says it ruled the way it did because of her supervisory role in the chain of events on the bags. And that's not my understanding of what Saxon said. Is that Saxon said she, in addition to her supervisory roles, she frequently touches and handles the bags. Isn't that what Saxon said?
Saxon does say that, Your Honor. You're entirely right. And
the fact that she's a supervisor was irrelevant to the outcome in Saxon.
I think that is correct, Your Honor, but I think it's also equally true that the fact that she's a supervisor is something that obviously the Supreme Court is comfortable with. It's not a problem that a role like a CSA can have some, aspect of their actual work that isn't typically a part of transportation. Really here, though, the frequency analysis that was explored with the district court just proved how difficult it is to actually divorce any non-transportation related function of these CSA's roles with the transportation functions.
Well, and we do need to have a limiting principle in this case. And I'm quite fond of Saxon because I suspect I'm the only person in this room today that was actually a ramp agent working my way through law school. And all I did was sling bags into the back of an airplane, but that's all I did. And, you know, to me, you know, Saxon Ring and the supervisor that was watching me, he or she would frequently have to, you know, pick up the slack when we were behind schedule and the plane needed to leave. But upstairs in the terminal at the ticket agent, it seems that the baggage handling is, you know, truly incidental to what their primary function is. And obviously they need to get the customer tagged and the bag on the belt. But at least the Frontier model is designed to minimize as much as possible the agent's participation in the process. The ultra low cost carrier model is, you know, you pay for everything and the customer does it. And, you know, to the extent customers can't cope with that, but the vision of Frontier is that that would be a very small part of the CSA's job. So, and okay, so if we are talking about frequency, then is it a 50? I mean, you know, how do you draw the line? And how do we draw the line here on this record?
Great question, Your Honor. Many cases have drawn lines where the actual involvement is just too attenuated with the actual flow of commerce or the actual flow of either cargo or passengers, where it just doesn't make sense that it is going to be too expansive and broadening the scope of the Section 1 exemption. For instance, at even an airport, there is a likelihood that certainly individuals that are so attenuated that even maybe just a surveillance component, that could be certainly a situation where that worker is just, rather than being a direct link in the stream of commerce, they're actually above it. That they don't have a tangible or direct enough role where essentially their absence would affect transportation such that the exemption applies. That's one potential way. In any kind of regulatory sense of someone being involved in transportation, I think the question of how necessary that is, how much that is actually directly affecting whether transportation occurs, is going to be what's really significant as far as drawing the line in a workable way.
Yeah, and we've talked about frequency, but at least one of the cases, I don't know if it was Singh or Fraga, talked about whether the movement of cargo would be a central part of the job. I guess I'd call that a centrality analysis. And I'm not quite sure how that differs from frequency, but can we say that moving bags is a central part of a CSA's job description, or is it something less?
It is absolutely a central or essential part of CSA's positions. We have testimony that it occurred in 100% of their shifts, 100% of their shifts. We also have at both positions. And we also have testimony where certainly even the design, even what CSAs are trained to do, to work on that agent assist side, where Ms. Joyner testified she works 50% of her time. They're trained to actually assist in actually helping the passenger fix their baggage and fix their luggage and also lift it as well. They're also conveying the actual cargo using the conveyor belt system. I know there's discussion with Mr. Ward on whether that's actually the conveyor belts transporting. That would be similar to arguing that last mile drivers, that it's really the trucks delivering. We're talking about workers here, not equipment.
Can I ask you, you go ahead, Judge.
What does the evidence indicate with respect to these individuals? And secondarily, if there was any evidence about CSAs generally, and that is how the conveyor belt ran? Was it a continuous belt, or did they control the on-off switch?
Great question, Your Honor. With respect to these plaintiffs specifically, they controlled the conveyor belt system by actually pushing a button after verifying that the cargo was set to the right location for that cargo to arrive at eventually its final destination after working through the baggage system. And as to
Was there evidence about CSAs generally in activating the belt?
I don't recall it specifically in activating the belt itself, but there was evidence certainly that the court relied on in reaching its decision that other CSAs performed their actual work the exact way that the plaintiffs testified, that it was typical for everyone that would be a part of this class of workers.
Did in the court making that finding, did it rely on the prototype type evidence or in the actuality evidence of other CSAs?
Well, nothing
Was that clear, my question?
I believe so, Your Honor. I think that the court relied on what the testimony reflected, the actual work was that other CSAs performed, and that was corroborated by the fact that the system design encouraged or required every CSA to operate the conveyor belt system in the exact same way for it to function in actually effectuating transportation.
Judge Babcock, you wanna-
Well, I just had a question about something that you had just said, because I did not see it in Judge Cruz's order. So obviously, Menzies and Frontier argue about the trainer, that this is the way that the CSAs are trained, and you have the testimony in the declarations of Joyner, Dixon, and Hobley. What I never saw is something that you just said existed, and I probably overlooked it, but I never saw where Judge Cruz actually said, I, Judge Cruz, find, despite this discrepancy of evidence, that I believe that the way that Joyner, Dixon, and Hobley perform their jobs is representative of the way that other CSAs did their job in terms of the frequency that they hit the button to transport bags, to the extent that they picked up bags. And I think you just said that that he did make that finding, and I'm not quarreling with that. I just never saw that. And so that was a little bit of a difficulty for me because we're not fact finders.
Mm-hmm. Your Honor, in detailing with specifics what the role entailed and how that is enmeshed in transportation, there's just no way that you can divorce the actual specific role of these plaintiffs with what typical work would look like.
As I understand, the
And
question
I-
is, what did the judge say?
Yes.
Did he say, these individuals are reflective of what happens actually generally? Did the judge so rule?
I don't recall that express statement, Your Honor, but what I do recall is that there was an absence of any evidence to the contrary, for one, as well as,
I mean, I have the same question as Judge Murphy is, but I didn't mean to talk over you, by the way, but Menzies and Frontier present the evidence of the trainer that says exactly the opposite of what Joyner, Dixon, and Hobley say, and let's say, I mean, this is not summary judgment. And we're talking about whether or not the class of workers would constitute transportation workers. And so I just wonder, technically, absent a specific finding from Judge Cruz, that the way that these three that he credited their testimony or declarations, that the way that they were performing their jobs was representative of the class of workers generally. I just don't know how that we can say, other than Joyner, Dixon, and Hobley were transportation workers, I don't know how we can say that about the transportation workers as a class, I mean, about the CSAs as a class.
you can see, Your Honor, in the fact that transportation does occur. And by how entwined, how intimately involved this particular position has to be for that to happen. And I would urge the court to be reluctant on requiring at that stage in the proceedings at an evidentiary hearing, evidence outside of the plaintiffs that would corroborate what the plaintiffs testified the actual work is that they're performing, particularly when it's so logically verifiable with the fact that transportation is occurring here.
Do you have a case that doesn't say anything about the frequency? Well, the frequency aside, that says specifically, if there is enmeshment in the transportation process, you are a transportation worker. Do you have a case that says that?
Yes, Your Honor, I think Lopez from the Ninth Circuit is helpful on that front because that was actually, I believe, a Menzies employee, if I'm not mistaken. It was someone who fueled jet airplanes for the transportation of cargo. So it wasn't someone who ever directly handled the goods themselves or did anything as far as moving the goods in even a really short aspect in the stream of commerce. They just were so enmeshed with fueling the airplanes that did perform the transportation that they really couldn't be divorced from having that direct and necessary link that Saxon requires.
Anything else? All right, I think your time's expired.
Thank you,
5
Your
minutes
Honor.
ago. We'll give Mr. Ward 3 minutes.
Very, very grateful for the extra time, Your Honor. I want to pick up on Judge Bacharach's question about what did Judge Cruz say. This is what he said at the hearing. Because we started to try to present evidence that was contradictory to what the plaintiffs were saying, and he says, hold on. The issue before the court is what these plaintiffs actually do with their work. That's wrong. That's not Saxon. It doesn't matter what the plaintiffs do, it's what the class of workers does. He then went on to say, if other employees were doing it differently, I don't find that persuasive of anything that I need to decide. That's wrong. And then in his order, this is what he wrote. Interstate transportation of goods is enmeshed in the work performed by these plaintiffs, and it is difficult to divorce them. The court finds Ms. Joyner, Ms. Dixon, and Ms. Hobley are transportation workers. That is a wrong finding as a matter of law, because what he is not saying is the class of workers are transportation workers. He never said that. He evaluated everything in this case solely through the lens of the plaintiffs, and that is simply a misapplication of the Saxon test.
But would that be harmless error on this record, though?
Not when we offered the evidence that tried to show it's otherwise there. I mean, at minimum, this should be remanded for the judge to evaluate the evidence under the proper legal standard. That's the starting point. My point is, I think this record is sufficient to not say this is harmless error. In fact, Judge Cruz got it wrong. And you asked where this is in the record. It comes in 3 places. One, there's objective evidence, right? We put videos in there. It's just, this is what they do. 20 minutes of video footage.
Videos of actual workers.
Videos of actual workers working the backdrop. There's 20 minutes of video.
That's not helpful. That's like a snapshot. That's like a poll.
It's 20 minutes of footage, and, you know, it's useful for the 20 minutes, I would say, Your Honor. Like, does that show what they do? You know, Ms. Shelby referred to the plaintiff said 100% of the shifts. Okay, that may be accurate, but if you spend 3 minutes of every shift doing it, that's not frequent. That is hyperbolic exaggeration, and that's what the plaintiffs did. And to your question,
We can look at the record. Do you say there are no cases that rule that enmeshment is enough?
that is a complete invention by the district court.
So you're saying are no cases other than the district court ruling here
Not just in,
saying enmeshment makes you a transportation worker?
there is no case that says enmeshment. There is no case that says gatekeeping. There is no
Say
case.
any integral?
That Saxon says directly involved, okay? And this is, Ms. Woods made the point that she said.
Well, Saxon says a role in the flow of goods.
And
Direct
as
and necessary role.
direct, necessary, as measured by actual physical involvement. These are words from Saxon. I think the word physical from Saxon is critical. It talks about this idea that you've got to be transporting the goods.
Other than the plaintiff in Lopez.
Correct.
who didn't transport anything.
And that's my case, Your Honor. I argued it at the Ninth Circuit. I'll be candid. I think the Ninth Circuit got it wrong, but even they didn't say enmeshment. They invented a
Hell,
different
yeah,
test.
I mean, yeah, they didn't use the word enmeshment, but the Ninth Circuit said also the opposite of what you just said, and that is that the Ninth Circuit unanimous panel found that the person that fuels the plane, albeit doesn't transport anything, is a transportation worker because he or she is directly involved in the machinery, like the conveyor belt, that transports goods across state lines. Right?
And even that, I can still distinguish Lopez, Your Honor. Like, I disagree with the Ninth Circuit. The test they created was a vital component. I don't know what that means, especially when you read it against Circuit City, because that is massively expansive when Circuit City says this is narrow. But at minimum, the fuelers in Lopez, that's all they did. They fueled aircraft 100% of their time, 100% of their shifts. So even if you compare this case to that case, frequency is satisfied there. It is not satisfied here.
Okay.
I'm very appreciative of the extra time, Your Honors. Thank you very much.
Thank you, counsel. Appreciate the arguments. That was very helpful. You're both excused. The case shall be submitted, and the court will take about a 10-minute break before the Spiehs case. Thanks.
Court is in recess.
Good to see you. Yeah. I guess you got no. Yeah, I suppose I'll go to that.
Well, okay, I'll go with you.
Yes, he went out right before and was like, does it work? What time did you get in town? I got in Sunday. Oh, yeah. So you know your sister? I have a sister. So I was able to hear her and we got because it was snowing. Oh, yeah. Which is wild. It's just like coming down, you know, it's like supposed to be 70. I mean, we mostly stayed in because we couldn't take the little pieces. Yeah. So we couldn't take the girls out early. Did you get snow? Yeah, Friday night. So I think I've seen you since that. Yeah. It was, yeah. Friday night. But yeah, we didn't really get out of it.
And then you checked in yesterday.
I stayed in the hotel Sunday night, but I had to work in for one day. So it was interesting. I had to go down there Monday morning. And it's like, hey, I'm checking out and checking right back in.
Did you get the same room though?
Yeah, I've done that before. So my flight was supposed to leave at 7:20 last night, and it left at 12:20 a.m.
Because of the snow or?
I think the last leg of the flight sometimes, I think it's the late of some pieces. So anyway, so then I had it at, so I think I learned my lesson, don't take the last one.
Yeah.
Because I had some stuff in Oklahoma City, and I was just thinking on Monday, it was relaxing. Yeah, me too. I know, yeah. It is great here, because you'll check us early.
Yeah.
Did you go to the front camp?
It's north, or it's
Oh, this is nice.
Yeah, I'm actually, I'm going back with Steve. Oh, okay. Wait, that'll be fun. Yeah, that'll be fun. You're all cheering. I'm cheering for the 76ers. I mean, I'm loyal to the Thunder over the 76ers, but I'm certainly loyal to the Eagles because it's the NFL.
No, we as a group, it's our team. My dad's still injured. Back.
How's your boy, the one that, you said the one that broke his arm or?
Yep. He had surgery and he's fully recovered.
Got through that?
Yep.
How old is he?
He's a senior this year.
Oh. So that was a baseball player? Yeah. Did that mess up his?
Yeah, it was a football injury and it messed up it was like high school baseball, but summer ball he was back.
Okay. Well, shoulder, broke, not his shoulder.
He tore his labrum.
Yeah. Yeah, that's fun.
Yeah.
Well, you're past that. Put
Yeah.
that in your bucket list.
Yeah, yeah. I hope that's all for this.
Well, you got 3, right?
Yeah. Yeah.
Your gavel almost. Well, it's probably hurt his few. So I've got to be here tomorrow. But it's, can't remember what room. 2 different pages.
So is that, do you do just certain panels or you just do them all?
No, all of them.
Oh, really? Well, and this one is in the, no. See, I've got 4 set now. I've got one in Roswell, New Mexico. And then I've got another one in May. So Roswell, I'm originally from Amarillo, Texas, so Panhandle, Texas. So New Mexico, familiar with. Roswell, down south. But, so I'll make a stop. My wife's mother's 93, and still got family in Amarillo, so I'll stop there, hang out, and then go to Roswell. But man, Roswell, it's not the beautiful part of New Mexico. Yes, yeah. Yeah. Well, you can always go to Carlsbad Caverns. Yeah. Yeah, no, Roswell is, no, well, it's kind of like Amarillo. You got Paladura Canyon and that's about it. But, so that drive down there is, yeah. Then I've got a wedding, so my wife told me, she said, well, we've got one of her nephews is getting married in Amarillo right after that. So I'm gonna go there, go to that, and then I'll stay with her mother for 2 days or whatever, and then wait for this wedding. Hopefully her mother doesn't kick me out. So is Colorado home?
It is.
My mother was born in Hunt. Yeah, which is, yeah, you've never heard of it.
Oh, I've heard of it. I've definitely heard of it, I've just never.
Well, it's not the beautiful part of Colorado. Old railroad town.
seated. Okay, we have two remaining cases. The next case is 25-3174, Spiehs versus Morgan. Mr. Baker?
Thank you. Linus L. Baker, appearing on behalf of the appellant, Dr. Spiehs, who's somewhere in the room. There he is. And I'd like to do 3 minutes of reserve rebuttal.
Good luck on that.
A public library, the genesis of this case started, the library hosted an event. It was about gender markers. Dr. Spiehs comes with a sign outside, standing there silently. One of the promoters of the meeting locks the door, stops him, and says, "You cannot come in here." And he stands there with the sign silently, and they call the police. Now,
Was this before or after the free speech activities policy?
That's before.
Okay.
So this is going to be one of the remarkable things, because what I think this thing went nuclear. They thought Jews for Jesus was the roadmap, because after these two incidents where the policy just said don't disturb, we filed the lawsuit, and then they turn around and amend their new policy. And it went nuclear. It was every bit as much as Jews for Jesus. There will be no free speech activities in this building. Holding or carrying signs, protesting. Now, whatever that means, that's negative speech. I guess you could say, I like Ike, but you can't say, I don't like him. Using expressive conduct or speech. There's the catch-all. Distributing literature. I can't even hand another person a book or a note. Acting as a public speaker. What does that mean? If I have a meeting and I want to address someone in the room, I can't do that.
Did your client schedule a meeting and
No,
do that?
no.
All right, so that's kind of
It's,
irrelevant.
all it is just a facial attack on that whole thing, Judge. Panhandling, requesting signatures, donations, contributions.
Would you agree if we focused instead on as applied, and we ruled against you, that would just kind of take care of the facial claims?
Well, I don't know that it would, Judge. There are two separate inquiries about as applied.
Well,
and-
if it's as applied, it means your clients were directly affected. If we address all those, the only other issues that would remain on facial were items that he wasn't
That could be.
he wasn't involved in, so he doesn't have any standing.
Well, he's still subject to them, Judge, and so a facial application.
What evidence do you have that he was chilled on the things that he never participated in before?
Well, the chill is an objective, it's not subjective. So would the idea that they call the police when he do these things, would that chill someone? Yes, it would. But I'm
Well,
not
it
going
wouldn't chill him necessarily from reserving a room. There's regulations on reserving a room.
You're right, Judge, and I'm not really quibbling about the as-applied or facial. The record shows that they applied speech prohibitions, and they did it unequally. They then.
Can I just make sure that I understand that, because I think this is an important question for me. I had read your briefs to be that this is solely an as-applied challenge. Am I right?
No, Your Honor, we did facially attack
Okay.
that, and just on its face. Look, in Jews for Jesus, that was a facial attack. The Supreme Court didn't even do a forum analysis. They just said on its face, you cannot have a prohibition that says you cannot have free speech, period. That's a facial attack. We do attack it
In a designated public forum?
in a designated public forum, and which is what this library is. So it is a facial attack. They simply said, you're not going to have free speech here. Now, we will give free speech to some of the participants, but not generally others.
Well, can I push back on that a
You
little
bet.
bit?
You're the judge.
Well, but this will just help me understand it. As I understand it, that there's not any quarrel with the fact that is a designated public forum, that, that a reasonable time, place, and manner restrictions are permitted. Do you agree or disagree with that?
I would agree that it's subject to strict scrutiny. It has to be
Well,
reasonable.
intermediate scrutiny
Well,
is time, place, and manner restrictions. but
If it'd be
that's-
like a sidewalk, it would be like, if it is a designated public forum, it's like a sidewalk. That's
Well,
the way I
Okay,
characterize
like a
it.
sidewalk. How's it like a sidewalk?
Well, it's a public forum.
It's not a traditional public
It's a
forum.
limited
It's-
public forum. It's inside of a library.
It is, and so Doe Albuquerque said, look, you come to a library, you're entitled to get all this information, right? And at the same time, if you're entitled to receive it, you're entitled to give it. And so,
The library can adopt a behavior policy, can it not?
well, yes, it has to be reasonable and has to have a connection.
Okay, so what's unreasonable about this policy?
Well, let me count the ways, Judge.
Okay?
He got arrested for holding up a blank piece of paper.
But the library didn't arrest him.
No,
Police arrested him.
the library said he's trespassing, get him out of here,
Right.
right? But he did violate their policy. He got put on the patron incident list.
Why can't a silent protest be disruptive to the ordinary operations of a library?
I don't know, like
I mean,
disruptive ideas?
Is your problem with the policies that it's vague?
Yes.
Okay.
You've got the videos. He did nothing to disturb anyone. He simply stood there outside with a sign. He didn't say a word. People come and go, and so he didn't disturb anyone. He never disturbed anyone. In fact, there are subsequent incidents where he came in and he had a flag, and another individual, Mr. Irvie, had a similar flag, an LGBT flag, and he had it draped, and Dr. Spiehs had another flag out. They said, "You're out, Dr. Spiehs, and you're in."
And that's, as I understand it, the evidence was undisputed that the way that the library had applied its behavior policy and its free expression policy is that it wasn't going to inhibit people with regard to their dress. You can have, say, a T-shirt. Mr. Evis didn't do what your client did. He draped the flag around himself, so arguably it was dress. Your client didn't use the flag as dress. Isn't that a material difference with regard to the way that the policy was applied?
I don't think so, Judge. He took a flag, both of them are flags. So now you're saying the way that I display the flag,
No, I'm not saying anything.
Well,
I'm saying
he's-
that that's the,
no, I'm sorry.
all right. Yeah, I'm just asking a question. Am I wrong that the policy as applied inhibited sign carrying and protesting? It did not inhibit anyone from having anything on their dress. I might be wrong about that.
No, you're not. And that goes to the unreasonableness. What is the purpose of saying I can convey the same message on a shirt or a hat, but I can't put it on this piece of paper?
Maybe nothing, but as I understand it, the only way, I mean, I'm trying to keep up with your argument, because you started off with, as I understood it, the First Amendment designated public forum
Yes.
issue. I think we've now segued into your equal protection claim with regard to Mr. Evis and Mr. Baston. Because I didn't see any discussion about Mr. Evis or Mr. Baston in connection with counts 1 and 2. So if we're now on equal protection, isn't it an undisputed inability of the plaintiff to have material, two comparable individuals, one favored, one unfavored, that were in materially identical circumstances with regard to the policy? And if the policy itself differentiated, I don't know how you can say that there's a fact question about why Mr. Evis and your client Mr. Spiehs are identical in all material ways.
Well, to be clear, the policy doesn't give an exception to clothing. It just doesn't say, right?
That's why I asked you about the way that it was.
Right, so you have two, at the identical time, one holds up a flag, just like this,
Right.
and another one has another flag draped around it.
Right.
One is not prohibited, one is.
Right.
All right, I say that's unequal treatment. That's the two flags with messages. In fact, the one flag was favorable, the other flag wasn't. We have other incidences.
I didn't think the flag incident was in the pretrial order.
It is.
Am I wrong about that?
You are, Judge.
Okay.
It is. He held, David Baston held a large sign, "The public library should be defunded for constitutional violations." That was okay.
Well, is that true? I thought that the evidence was undisputed, that the library told both Mr. Spiehs and Mr. Baston to leave. The police then came, and then after the police talked to your client, Mr. Spiehs left, Mr. Baston stayed. But I did not, can you point to me any evidence that the decision to allow Mr. Baston to stay and Mr. Spiehs to leave was done not by the police department, but by a library?
Well, the library is the one that instructs the police who can stay and who cannot. So the library governs
Have
that.
evidence that, and if you can you point me to it, because I didn't see it in the briefing, that there is testimony either by a declaration or deposition that the library told the police to tell Mr. Spiehs to leave and to tell Mr. Baston that he could stay.
They did not tell Mr. Baston to leave. So that part is in the record. They did tell that Dr. Spiehs had to leave. Same way with the blank paper.
They meaning the police.
Yes, they told the police, the police are the enforcers.
All right.
So I'd like, I mean, if you have, I'd like to have 3 minutes of my rebuttal time. I see I've got 3, but I'm happy to continue on with this.
All right, you can reserve.
Okay, thank you, Judge.
I'm so sorry. I'm not trying to cheat you out of your rebuttal. Maybe he'll have pity on you because it's. But can I ask you one question about something you said earlier?
Sure.
I thought Verlo versus City of Martinez specifically said that that when you talk about a policy that restricts free expression in a courthouse, that it's content neutral to do 2 things. One, to prohibit picketing and protesting were 2 parts of the ordinance that prohibited those 2 things in a courthouse. And I thought that our circuit said in a presidential opinion that those were content neutral. Am I wrong about that?
I don't think you're wrong about that, although when we talk about picketing or protesting, that's an amorphous concept in terms of protesting by its definition is negative. So
Well, then why did we just get it wrong? It's saying that protesting was content neutral and verbal?
Well, and you've got a courthouse. It's not, I don't think it's apples to apples. You have a much higher, this is a library which Dovey Albuquerque said, okay, look, all bets off, it's free speech. And so I liken it to a sidewalk in that sense. So I think it isn't fair to take that. Reasonable has to be looked at in terms of the other. So just holding up, I mean, I can hold up the message with a placard, have the same message on a shirt. The library says you can't do that, but you can do this. I don't see the reasonableness of that at all, and the idea that if I just hold up a blank piece of paper, that got him on the Pitts list, and then he was banned without even knowing it. And then he'd show up and said, oh, by the way, you're banned. I know you didn't know it, but now, and every time it's increased. Now what would have been a slap on the hand, now he gets a 90-day ban. And so we have that issue before the court. So hopefully.
I'm sorry about your rebuttal.
That's fine. Thank
I
you.
apologize.
Good morning. May it please the court. Samuel Green on behalf of the Appellees. The kind of stereotypical image burned in a lot of Americans' minds of a library is this, uptight librarian shushing a group of kids for laughing too loudly or talking too loudly. And that's because the quintessential aspect of a library is that the patrons, the users of the library have access to information. They can read, they can study in an environment that is conducive to those activities. The courts have held that libraries are limited public forums as far as access goes. But there's no case.
Is that right? I mean, I don't want to pick on semantics, but Judge Abell and Doe specifically said it's not a limited public forum, it's a designated public forum.
So, yeah, let me articulate that. Crimer, the Third Circuit case, does call it a limited public forum.
Right.
Doe, this court went through the case law and says there's no separate category of a limited public forum, but a library is a designated public forum for a limited purpose. It's been designated open for certain activities, and those are library-related activities such as studying and reading.
Well, I hate to keep picking on you semantically, but I know you said that in your brief, but I did not see anywhere in Doe that he called it a designated public forum for a limited purpose. He called it, based on Hawkins, a prior precedent, that it was just a designated public forum. Now, he did acknowledge that a library, by its nature, and citing Crimer, that it opens up a forum for particular purposes, reading, writing, and that kind of thing. But I don't know that he included the characterization that you did, designated public forum for a limited purpose.
And that might be some of my language, but based on what the court stated in that case. I mean, there's other cases that, a forum is only open to the extent it's designated by the government body. And here, the library's only been open for certain things. There's no evidence in the record that the library's ever let anyone protest inside there. It's just not there. They've not opened the library to public expression. They've opened it for public access to information, to reading, and to studying.
Well, what about Mr. Baston? Free speech died here.
That was Dr. Spiehs' sign, free speech died here today.
Well, Mr. Baston had a sign critical of the free speech problem, free speech policy, right?
Mr. Baston was walking through the library with a sign. It's not in the record what his sign said or what was on his sign.
Okay.
But it is in the record that he was confronted by library staff and treated the exact same way as Dr. Spiehs was.
Is this the 125?
Date-wise?
Yes.
That was the December 1, yes.
December 1, yes.
Of 2025.
And Mr. Aravi was with him?
I don't believe Mr. Aravi was there on that date.
What was it? There was an incident where Aravi had a sign 8.5 by 11, and the plaintiff had a sign 11 by 16.
That was, and the record's a little bit unclear, but the incident was right after the November 25th library board meeting. Both men had attended that meeting. They went upstairs. Dr. Spiehs started protesting in front of the library help desk with a sign that said something to the effect of free speech died here today. Mr. Aravi was just walking around with a copy of the new policy that he had received at the meeting. He wasn't standing there protesting.
Displaying it.
That is not in the record. That is an allegation of plaintiff, but there's no evidence that he was.
The record just indicates he was carrying it,
Yes.
and the record also indicates that the plaintiff was brandishing it, his sign, or waving it?
He was standing in front of the library help desk, like the information center, and just protest, like, yes, holding it up. I don't know about brandishing. I'm not sure what brandishing means, but.
Right. So in addressing the equal protection problem, are you saying that because one was using it as speech in a demonstration, is a reason to treat him differently than the person who just had the regulations? Is that the distinction?
Yeah, he was not standing there holding it up. He was just carrying it after the meeting where that had been distributed. The library board had distributed copies of the proposed new policy prior to taking action on it.
And you're telling me if I dig into the record, it will indicate that there's no evidence that he was doing, Mr. Aravi was doing anything but carrying it?
That was the interpretation of the library at the time, of the library staff at the
That was
time.
the evidence, the record evidence.
I'm not sure how much evidence is on that as far as Mr. Aravi goes. There was a couple blanket allegations from counsel, and that was the extent of it.
Well, if we were to conclude that Aravi was in fact protesting by the way he displayed the policy, wouldn't you agree that the difference between the 8.5 by 11 and the 11 by 16 would be immaterial for purposes of the equal protection claim?
Probably, but I think the intent behind what the actor is doing would not be, and I think that's where they would not be similarly situated. They're not in every material respect.
Interestingly, though, that was the very distinction the district judge made, the district court made, the size of the sign.
That was a distinction that the court relied upon, yes.
Well, what other distinction in that incident did the court make to take care of the equal protection claim? That's all I saw. That's my
Yeah, I think the court mentioned the flag incident, which was not in the pretrial
No,
order.
I'm talking about this incident on November 25th.
The court, I don't believe the court, and I could be misspeaking, but I don't recall the court's decision focusing on who specifically or what specifically she was referring to when she used the 8.5 by 11 distinction. And maybe I could be wrong on that.
Well, you are.
But-
I mean, she said
okay.
that in the decision, and you say there was another basis that she ruled on, and I want to know what that other basis was for that incident.
I cannot answer that at the moment, Your Honor. I don't believe that the evidence is that Mr. Aravi was protesting at that, which would in itself be a material difference, a critical material difference.
And you're saying,
Without a finding.
Do what? I'm sorry.
Never mind, we're not into the finding.
you're saying the flag incident was not in the pretrial order?
As far as the factual summary of it, yes. Correct.
Because I think Mr. Baker said that it was.
Yes, I heard that.
Was the 11/25 incident in the pretrial record?
Yes. As far as Mr. Spiehs' actions and what led to his being asked to leave, yes.
As an equal protection claim?
I believe that it was in the factual section, the factual summary.
And he did, and Mr. Spiehs does say in paragraph 42 of his declaration in district court that Mr. Aravi came in and displayed a print out of the policy. So at least his evidence, viewed in the light most favorable to the plaintiff on summary judgment, was that he was displaying this paper.
Yes, I would not disagree with that. But I guess displaying is undefined. There's no evidence that he was standing there holding it up. I mean, just carrying something through the library could be displaying. It's on display.
But we're on summary judgment. I'm not trying to argue with you, I'm just trying to figure it out. You know, if we view paragraph 42 of the declaration and credit it and view the evidence in the light favorable to him, and the only thing that we have from the district court is, well, it was a difference in sizes, I don't know that we can really credit your distinction that displaying was not sign carrying under the policy. You know, what is displaying?
Yeah, and I know and I'm not trying to avoid the question. I'm trying, as I'm looking back here, I'm not sure any of the factual information about Aravi was in the pretrial order, actually. And that was going back to your question, Judge Murphy. No, that is, I think the district court was looking for similarly situated in every material respect. The evidence was that the library interpreted what Dr. Spiehs was doing to be protesting, which was prohibited. The did not interpret what Mr. Ravi was doing to be protesting. And that was not fleshed out factually. Plaintiff did not flesh that out factually. I'm sorry.
Again, I'm not trying to argue with him, just really trying to figure it out. It was inclusive of protesting and sign carrying. And so maybe Mr. Ravi wasn't protesting, but he was certainly sign carrying if he was displaying the paper.
Well, he was carrying a policy that was just handed to him by the library. Whether he was displaying a sign or not is, I guess, debatable maybe.
What is the source of evidence that we would be relying upon? Would it be a declaration from librarian staff as to what Mr. Ravi was doing? Because there's a possibility that the district court put its own polish on it, called it, I don't know, declaring, whatever. But what we need to do is look at the record. So what's the source of the evidence of what Mr. Ravi was doing on 11/25?
I don't believe there really is any. The record is pretty empty there. And it would be declarations, but again, the library staff, when they thought other people were protesting, that is in the record, like Mr. Baston. He was walking through, holding something up, they thought he was protesting. They created a Pitts report for that. They asked him to leave. They treated him the same. It was something that was interpreted completely differently, that maybe they didn't interpret, and yeah, it's not in the record. But that's inherent in running a library. You know, the staff is, for any behavior, the staff has to make those judgment calls, and it's based on experience.
I'm just trying to get to the source of the, did Mr. Ravi submit a declaration or an affidavit?
No.
But the plaintiff did?
Yes.
And so, and some of the librarian staff did?
Yes.
So what we have to do is search around those to see what is stated in the declarations as Mr. Ravi's activities on 11/25.
Yes, that would be the extent of it,
Is that
yes.
what we have to do?
Yes,
Okay.
that would be the extent of the evidence on that.
How would holding up a blank piece of paper be impermissible under the policy?
Well, it's the behavior itself. It's not the message, and that's the exact point. The library's not regulating the message. They're regulating the conduct and the behavior. And protesting is protesting, whether there's a message being conveyed, whether it's a vague message being conveyed, whether there's no message being conveyed. The message is irrelevant to the library's policy. It's irrelevant to their decision-making on it.
But it's negative.
It's-
Protesting by definition is negative. If I walk around downtown Denver saying our system of justice is second to none, am I protesting?
I think so, and I think some of that goes to the context here. The sequence, Dr. Spiehs had been in the library multiple times in a row, several days, and had stood in the same place holding up messages. And then he goes to the same place holding something up, and it was blank, but that's the experience of the staff, like the intent. The behavior was protesting. That was the action that was being done. Whether a specific message was contained on the sign, in the context of, or the sequence of those events, he was protesting, and he was protesting presumably the new policy, but that's a presumption, not in the record. But the blank sign, I think, clearly shows that this is not content-based restriction. This is content neutral.
On that day?
On every day. There's nothing in the record that shows at any point a content-based decision.
Okay.
They did not allow the protesting regardless.
And I know it may not be in the pretrial order, but what's the distinction between the individual having the rainbow flag draped over his shoulders and Spiehs carrying a Gadsden flag?
The the intent behind it. The library doesn't regulate the messages with clothing. I mean, like, that came up earlier.
So if he draped the Gadsden flag over his shoulders, that would have been the material difference?
That would be my understanding, that that wouldn't even have created an issue, yes.
But I don't understand, now, you said it's the intent. We're not looking at it as intent. We're looking at whether or not what is going on is disturbing or potentially disturbing to the patrons of the library, right?
Yes,
We don't care one hoot about his intent.
that is correct. That is correct, and I probably didn't say that very articulatively, but,
Okay.
but one person was protesting with the flag, one person was simply wearing one. There is a big difference when the policy prohibits protesting. It doesn't prohibit wearing scarves or wearing flags as scarves.
All right, your time's expired. You could give Mr. Baker 2 minutes.
Thank you, Your Honors.
Your Honors, you have video. In this modern day and age, they have video. They videotaped everything. And the lower court had that video.
Did it have video of the 1125?
Yes, yes,
And is video on Mr. Iravi?
yes. In fact, you'll see in that video where both of them are out there holding it, they can't get anybody's attention. People just walk on by.
But that doesn't,
All I'm saying is there's video. So the
but
evidence,
what you're saying is that the video says that he was flashing the 11 by 16
yes.
taper around.
Yes, he was doing just like that. You can view it for yourself. They were absolutely quiet
Okay.
doing that.
So you're saying they were both doing the same thing?
Absolutely.
All right, and one was nabbed and the other one was not?
Every time. Irvy, his name is Irvy, he couldn't get busted. It was always Dr. Spiehs was the naughty child.
And did you include a claim in the pretrial order for this, an equal protection claim on this 1125?
Yes, yes, Your Honor. And I want to point out in the pits, the only citation they ever wrote up Dr. Spiehs was not for disruption or doing any of that. It was, you just didn't obey our orders. Now, so I would urge you, because the lower court wouldn't watch the videos.
Would you do me a favor? Would you supply a 28J letter that identifies the video and the timestamp and where we can find
I can
it in
do
the
that,
record
Judge.
After.
I think we did that in the lower briefing and all that, but yes, I can do that. So you don't have to watch.
Specifically where in the video?
Yes, we sent video. I think they sent video, we sent video, so I can pinpoint the timestamps on that, so you don't have to.
All right. Well,
Spend
your
all
time's
the time.
expired.
Thank you,
Seeing no
Judge.
one- Thank you. We appreciate your arguments. You're excused and the case is submitted. All right, if council are ready, let's move next to 25-4124, Utah Political Watch versus Musselman. Mr. Miller, you may introduce yourself and proceed.
Yes, thank you, Your Honor. I'm Charles Miller with the Institute for Free Speech. I'm here today on behalf of Brian Schott in Utah Political Watch. I'd like to reserve about 4 minutes for rebuttal, so we'll see how it goes. All right. Speech restrictions based upon the identity of a speaker are all too often simply a means of controlling content. That's from Citizens United. And in addition to that, in Reed versus the Town of Gilbert, the Supreme Court made clear that distinctions based upon the function of the speech or the purpose of the speech are also subject to strict scrutiny because they really are also designed to go to content. And then I just want to note something else here from the Supreme Court before moving sort of discuss the facts here a little bit. Today's St. Patrick's Day. I got to mention Hurley versus Irish Americans. All right, so we quoted them in the brief as well for the purpose that the state cannot intrude upon the exercise of editorial content or judgment. Now, in my brief, I made the mistake of when editing had an id there instead of the citation, but that was the case we were citing 515 US 557 at 570.
Why isn't this a content neutral policy?
Yeah, so on its face, it's not content neutral because.
Because it excludes independent?
That's right. Yeah, and so what we're doing is we're taking media, so you have a policy that creates a limited public forum or non-public forum, what have you. It's pretty much the same in this instance for journalists. And then it's creating this artificial distinction that they began in 2025 to say, but not independent journalists or bloggers. And it's a distinction that makes no sense, and they have no reason for it. I asked them, where you have space constraints, is there a reason for this? And they said no. They said the reason that
But
they're...
that's in the record, they say they don't have any space constraints?
Yes, that is...
That's all right, that's all right.
Yeah, that's in the record.
You have it in your brief, where we find it?
I have it in the brief, but I just want to make a slight distinction. I'm going to distinguish between attorney arguments and...
Between the what?
Between attorney arguments and what their client said. So when I cite the depositions to say that, they cite the sort of argument that they make or a declaration. I think they probably cite the declaration.
What about, there's favorable parking concessions. Now, surely that's a space issue.
Sure, but like there are 6 parking spots. Nobody cares about that. If you don't get a parking spot, you just don't get a parking spot. They're first come, first served.
I thought they had journalists reserved for the special people, but not for...
Yeah, sure. Yeah, they do. I mean, we wouldn't be here arguing about parking. Parking's immaterial. That's just a bonus thing. They've got 6 parking spots. They have 140 people with passes. I'm guessing not under all 140 of them squeezed in there. And actually, they talk about 140 pass holders. It's 20 institutions. This is the entire state of Utah. They have 20 institutions right now that have credentials. And we would be 21.
By institutions, you mean traditional paper, newspapers, and television and radio?
And blog. And a blog. There's a blog there.
A blog has been recognized.
Yes, there was a blog that was called Building Salt Lake. It is self-identified as a blog, and it's actually not even a state policy blog. It's a blog for urban development.
But I'm looking at the policy, and it says blogs do not qualify as for a credential.
Yeah, I find that interesting, yeah.
Okay, so you're saying they did credential a blog contrary to the policy?
That's right.
And have they credentialed an independent media yet?
They credentialed Utah Policy, which utahpolicy.com, it's out there. It's basically a news aggregator, and it runs some pieces that seem to be opinion pieces.
I assume that would qualify under their interpretation as an independent media.
I think that'd be independent. And also, it only has one employee who's its editor, and she's the person.
Is this in the record?
Yes, it's in the record.
All right, so and Utah Political Watch is one person with a website
Yes,
and a blog.
that's correct.
And
Yeah.
an employee, another employee.
He has a person who is his wife who serves as an editorial process, a copy editor.
Okay.
Not a control editor, a copy editor. So she does that for him, and he does long-form journalism. He does the same work that he's been doing throughout his entire career. He breaks lots of stories. He interviews the U.S. senators and everything else, and so he's running a
doing
news
the
site.
same thing he did when he worked for the Tribune?
Yes.
All right.
Yeah.
Except he doesn't have a publisher.
They doesn't have that institution behind him. He's out there on his own. He's got his, he does his 4 to 10,000 views per article that he puts out there, but he's doing it all on his own.
Is he an LLC? Is he a corporation?
He's an Inc. He went C Corp. I don't know why, but he did. And he also.
Is that similar to Citizens United then?
Yeah, yeah, sure, right? So, so it's a corporation out there that's doing this, and,
But-
you know,
but
that's
his
why I
me-
started with
his-
Citizens
His
United.
message is all digital, it's not print.
Yeah, that's correct. I mean, I think lots of things are that way now.
I'm just
Yeah.
asking a question.
Yeah, no, that's fine. Yeah, it's digital and, well, also, you know, he's got the video, but I guess that's digital too, right? So, yeah, yeah, so he does that. And so, you know, and also, I really want to emphasize about the policy.
Anyway, so the reason it's not content neutral is because it's directed at the type of speaker? Is that the problem here, i.e. blogs and independent media?
Yes. And that.
And how is that viewpoint discrimination under the cases?
Yeah, so under the cases, the cases talk about how viewpoint is not limited to political viewpoint, and it really should be viewed in a very broad way. You know, so basically the choice of how to repost or edit is something that is viewpoint. And specifically, I think that, I'm sorry, I think that the Bellotti case talks about this from the Supreme Court, talks about that things should be judged based upon their speech worthiness, and not the message. If you look at the Lakewood case, they were regulating the location of newspaper racks, and that was determined to be too much discretion that they had. And, you know, and so that's part of the argument here with respect to this content, because they have this, where they have independent media, some get in, some don't, one employee, some get in, some don't. We're really saying that there's a lot of discretion that's there, and the problem with that discretion is when you give that much discretion, it creates the ability for there to be prior restraint.
For there to be what?
Prior restraint. The idea that we don't like this, so we're gonna not credential them, we're not allow them to
I
have
thought
this.
you would have said it awakens the tiger viewpoint more so than prior restraint.
Well, that's my point. It allows, it affords them the option then. They've got the leverage there to say that what they're doing is based upon the policy, but they're really doing viewpoint discrimination.
And is that furthered? Now, you don't have an equal protection claim.
I do not have an equal protection claim.
You're claiming discrimination, but it's not as an equal protection claim.
No, because the analysis is pretty much the same under equal protection in the First Amendment.
So the fact that they allow a blog when they say they're not going to, but they don't allow your blog.
Yeah.
Stuff like that reflects upon, you say, prior restraint and maybe viewpoint. Is that
It's definitely viewpoint, right. Yeah, so I mean, what it's showing is it's showing that they're not following the policy that's going on. Because they're not following the policy, it is creating a viewpoint or content-based restriction that should be viewed for strict scrutiny.
Do we need to know, as an evidentiary matter, how your client's viewpoint differs from one of the privileged journalists or even the blog that's privileged?
I don't think
Do I have to know what their message is?
I don't think you need to know it because he's been excluded, but I sure provided it for caller.
Is there anything in the record that indicates that your client has a particular viewpoint? I mean, I know he was critical of some staffers.
Well, not just the staffers. So like right before he applied for this, 5 days before he applied for this pass for 2025, he published a story indicating that I think it was a Speaker of the House or President of the Senate, you know, was engaged in unethical behavior as alleged by another entity that filed a complaint. And he got lit up on X about that. He got called a former journalist by the Speaker. I'm sorry, by the President. And so we see that they have lots of animosity against him. And to add to it, the defendants in their brief they filed here, they said, well, you know, those are not the only ones. And they showed you some X posts from others, you know, insulting my guy too. And they're saying, well, look, we didn't take away his credentials back then, you know, earlier in the year when he was still with the Tribune, but it certainly shows the animosity. And again, For the policy from 2019 through 2024, they allowed bloggers and independent media to be there. They only changed the policy once my guy left, and he was the only one that's been excluded from this. And they said there's no space constraints. They admitted in deposition, after a very long pause, that he's a professional journalist, that he's doing the work covering there. So he meets all the substantive requirements. He does journalistic work.
Does he make money from his
Yeah,
type?
yeah, absolutely.
Subscribers or?
Yeah, he's got subscribers and then he gets the ad share as well from the podcasts and the like. And then again, he makes enough money that, he makes his living off of this, and then he's got an insurance policy, so he could be sued for libel. He's got $2 million worth of coverage. He's as professional as it gets with this as anybody else.
Did I understand? What I thought you said that when the policy was initiated, was it 2019?
Yeah, 2018.
That he was the only one excluded?
Well, so
So there were a bunch of applicants.
yes, so in 2025,
Okay.
he was the only person excluded.
You mean there was a gaggle of applicants, and all the applicants were authorized, and he was the only applicant that wasn't?
That's exactly right, for
What I did-
2025.
What I didn't understand about your argument before or now is, was he the only blogger that was denied? In other words, I understand that he was, but if he was the only blogger that applied, he was also the only blogger that was automatically disqualified under the policy.
Building Salt Lake was a blog, is a blog.
Other than Building a Salt Lake.
Well, yeah, other than that, yeah. But there was another publication that was simply one person, or there were two other publications that were one person that were permitted. Because what they're saying is you need to have an editor, you need to have somebody over you. But there were two other publications that were like that. So I've got 2 minutes left, so I'll save the rest for.
Okay, thank you.
Thank you.
May it please the court, Daniel Vitaliano for defendants, appellees, the Utah legislative officials. I want to first make very clear, we're here on appeal from a 12B6 dismissal, and the court then subsequently denied the preliminary injunction motion as moot. There's been a lot of talk about evidence in the record. So first, it's a 12B6, so we're limited to the allegations in the complaint, documents attached to the complaint.
Let me ask you this, are the things that Mr. Miller said are in the record that are in the complaint as to him being the only person excluded in 2025, that one blogger is in and he's out?
Sure, I can walk you through the allegations in the complaint, followed by the record. So,
did he allege that in the complaint, either of those things?
at Exhibit 12 to the complaint is a list of all the entities that were credentialed for the 2025 session, as well as other entities that were not credentialed, and their credentials were denied. He was not the only applicant that was denied for 2025. There were 3 others, all for the same reason, that they are self-edited. As to the question of being a blog, at paragraph 69 in the amended complaint, they allege that Building Salt Lake is a blog, and that cites to Building Salt Lake's website. If you follow that URL, which is incorporated into the complaint, it makes no mention of Building Salt Lake being a blog. So to the extent that allegation in the complaint contradicts the document that is incorporated in the complaint, the document would control.
So in other words, if you have an allegation that you would credit and it incorporates a website that is agnostic on the issue, then we should assume, notwithstanding our liberality under 12B6, that because the website was agnostic, that the allegation in paragraph 69 couldn't possibly be true.
Correct. It's just an inaccurate. It's an
No
inaccurate.
sense to me.
It's an inaccurate quotation that they're quoting the website, and if you go to the website, it's not quoted as being a blog. It doesn't say it's a blog.
Does it say it's not a blog?
It doesn't say it's not a blog, but it says nothing about being a blog.
But there's
And
an allegation in the text of the complaint that it is a blog.
Sure, and they allege that it is a blog, but just alleging that it's a blog is conclusory.
You just corrected me in saying we're not on summary judgment, we're on 12B6. We're talking about allegations of the complaint.
Yes, but the cited document, the URL website, is incorporated into the complaint.
But the cited document, you say, does not negate the allegation, it just doesn't necessarily support it.
They're quoting language that it says it's a blog. That quote does not appear anywhere on the website. That's our point on that. And there is specific evidence in the record, Appendix Volume 2, pages 20 to 24, Declaration of Andrea Peterson, that walks through these entities and explains the basis for credentialing entities like Building Salt Lake or other entities that were identified.
And that should be incorporated into the complaint for 12B6?
No, that's in the preliminary injunction record.
Which was only denied based on mootness, right?
Correct, yes.
So on 12B6, what you just referred to should be out of our minds.
That point about those entities, correct, yes.
Okay.
But I'd like to state one.
Wait a minute. The attachment to the complaint, you said, that lists the ins and the outs. Does it identify them, whether they're blogs or not blogs?
It says that they are self-edited, and that's one of the criteria determining whether they qualify as an established reputable news organization under the policy.
My question is, do they say blog?
It does not say blog or not blog. But I want to take one step back. It's undisputed that the forum analysis applies to this case, and under that three-step framework, questions about viewpoint discrimination or anything of the sort only come at step 3, and that doesn't get reached until plaintiffs satisfy their burden at step 1 to establish that there is a burden on their First Amendment activity.
Well, you talking about Smith versus Plotty?
Smith versus Plotty, also the Supreme Court's decisions in Pell, Saxby, and Houchins.
Well, as I understand it, and you tell me if I'm wrong, your argument about prong 1, whether or not it impeded Mr. What's his name, Mr. Schott, his ability to newsgather is great. That's just not what his claim is. His claim, much like the other discussion we had in the prior case, is that once there is a forum that is provided under the media credentialing policy, that it cannot be viewpoint discriminatory.
Sure, but under Cornelius, the Supreme Court's decisions of this court, Hawkins, that set forth the forum analysis, at step 1, the plaintiff has the initial burden to allege an infringement on their activity.
Where does it say infringement? It says that the activity has to be protected.
Sure, whether it's...
And that's why in Smith versus Plotty, where the court was dealing with a prohibition against the journalist being able to gather news, made sense at prong 1, because that was an infringement of a protected activity. His argument is not that his ability to news gather was being infringed upon, but once there was a protected activity and a forum that was provided by the state for him to exercise that protected activity, it couldn't be viewpoint discriminatory.
Sure. His count 1 of the complaint is pleaded in terms of his First Amendment right to news gather. And whether that activity is protected is defined by the Supreme Court in cases like Pell, and it explains that the First Amendment news gathering right guarantees only access to sources of information that are available to members of the public generally. As we set forth in our brief on pages 18 to 20, we explain all the specific information that the plaintiffs are seeking, and all of that is available to members of the public generally.
All right,
So the activity that he's seeking to gather that specific information, that's not protected by the First Amendment.
And that's fine, and I think he'll get up in the rebuttal and say that's fine, because he never mentions that theory in his briefing.
The district court explained they don't respond to it, they never responded it.
Right, and I don't think that we're being asked to deal with that hypothetical claim, or that he may have presented in district court. As I understand it, his claim is that if it was viewpoint discriminatory, in other words, if he was denied a media credential because of antagonism for his past reporting, then that is a violation of the First Amendment.
For counts 1 and 2, yes, count 3 is a retaliation claim. So counts 1 and
Right.
2 under the forum analysis, because they concede it is a limited public forum at amended complaint paragraph 109, page 31 of their brief. So then the standard is reasonableness and viewpoint neutrality. There was some discussion before about whether it's content-based or not. This court's decisions in Brown, we cite, explain, and Supreme Court decisions that when you're operating in that type of forum, distinctions can be based on content, and that's
But they
inescapable.
can't be based on viewpoint.
Not viewpoint, it's viewpoint and reasonableness.
All right, that's why I want to get to paragraph 116 of the complaint. Additionally, Schott was considered a professional journalist by defendants since he started receiving credentials over a decade ago. It was only after he angered defendants with his reporting and started his own publication that defendants suddenly determined Schott was unprofessional. This shows plaintiffs are being punished based on the viewpoints expressed in Schott and in UPW's reporting. Since we're here on 12b-6, and we're here not on the unqualified ability to newsgather, but based on viewpoint discrimination, why doesn't paragraph 116 suffice at 12b-6 to show viewpoint discrimination?
Sure, I would point you to Exhibit 10 of the amended complaint, which was the letter denying his appeal from the denial of his application. And it explains that he was previously credentialed when he was working at the Salt Lake Tribune, which has always qualified as an established reputable news organization. He was fired from the Salt Lake Tribune in the fall of 2024, and this is set forth in that letter explaining that then he started his own organization, Utah Political Watch, and that does not qualify under the policy as an established reputable news organization. The policy turns more on the organization, not the individual journalist.
According to you, according to him on paragraph 116, and according to his allegation that there was another blog that was also would have been disqualified under your media credentialing policy and was allowed a media credential, why doesn't that at least get you past 12b-6?
Because the initial allegation is squarely contradicted by Exhibit 10 to the complaint, explaining that his departure from the Tribune was the reason why he was no longer eligible and that his new entity did not qualify. And when a document is attached to the complaint, that trumps any contradictory allegations. That's well settled. And
Why is Utah Political Watch a disreputable news organization?
I wouldn't say it's, part of it is being established and reputable and the criteria that are considered, and they cite a declaration that was submitted below in the complaint explains the considerations that legislative officials consider, and that's whether a journalist is subject to editorial oversight, whether there's institutional framework at the entity. And Utah Political Watch is a self-edited, self-run, one-man operation. Mr. Schott is not responsible to anybody but himself. Nobody edits his work. He alleges that he has Ms. Morell as an editor, but he did not disclose that on his application.
His work is absolutely no different than when he was at the Tribune.
Sure, he's at a different organization.
The fact that he doesn't have an editor makes his news organization ineligible for this credential, and credentials may be denied or revoked for any reason. I think that is a bit of a red flag here, but does not represent an established reputable news organization or publication. That seems completely standardless and vague.
I would not call that standardness or vague. It's very similar to the policies that the Seventh Circuit upheld in the Evers case as reasonable and viewpoint neutral, that the criterion there was whether you're a bona fide correspondent of repute in the profession. It's no different than the DC Circuit policy.
Which he is.
Those policies,
professional careers.
Those policies turn more on the individual journalist, whereas this one turns on the entity. But I would say the White House credentialing policy employs that same language, and it has always been understood.
It was struck down.
I'm sorry?
White House policy was struck down.
Not in that,
when it tried to exclude a journalist.
In the AP case, that's separate. I'm referring to the Ataba case, which was the denial of a hard pass, and that employed that same criterion, whether you're a bona fide correspondent of repute in your profession, and that has always been understood to exclude independent journalists, bloggers. That's why we explain in our briefing when the White House said it was going to open up the briefing room to independent bloggers, it received 7,400 applications within 24 hours. Those individuals of, social media influencers, citizen journalists, they were never eligible under the White House's policy that was upheld in Attaba. And more specifically, I would say to the allegations of viewpoint discrimination, I would again point you to the Evers case in the Seventh Circuit attached to the complaint at Exhibits 12 and 13. It gives a list of all the qualifying entities that have been given credentials, and it shows there are journalists and organizations of diverse viewpoints, from the Salt Lake Tribune, which is generally regarded as left-leaning, to Deseret News, which is generally regarded as right-leaning. And the Seventh Circuit in Evers says that, that refutes any suggestion that credentials are being distributed based on viewpoint when you have a diverse collection of entities with varying viewpoints.
Wait a minute. What is it that shows in the filings we can recognize that there's diversity of viewpoints in the crowd that's allowed in?
Attached to the complaint is a list of all these entities, and then...
Does it say lefty, righty on the attachment?
It does not there, no, but in the preliminary injunction record, it further explains it. But this court can...
We're still at 12b-6.
Sure. Even if the court were to not want to make any assumptions about organizations like that, at Exhibit 12 includes all the other entities that were denied, and it gives the reason for it, that they are self-edited. And that explains that the decision to deny Mr. Schott's credential was consistent with other decisions.
Well, there's also an as-applied challenge, and he makes allegations of animus or retaliation against him for speech that he's engaged in. I mean, what do we do about that? I mean, doesn't that at least raise an inference that he was denied a credential because of speech that he made that the government, your clients found
Sure. So
offensive?
there's two separate inquiries there. First is their counts 1 and 2, First Amendment claim. Then there's the count 3, which is the retaliation claim. I'll start with the retaliation claim. The district court applied this court's decisions in Smith v. Plotty and Shiro versus City of Grove. My friend on the other side, they do not cite that in their brief, where the 2 paragraphs, they address the retaliation claim on pages 38 and 39. They simply don't address those. And those explain that, not receiving a credential it's a de minimis injury. It's not cognizable. It wouldn't chill a person of ordinary firmness. And in Smith v. Plotty, the court looked at whether alternative avenues of information were available. And as we explained, all of that's still available. It also looked to whether the decision in any way prevented the individual from speaking out or maintaining a website. Mr. Schott has continued to maintain his website even without a credential. So that's on the retaliation claim. On the claim subject to the forum analysis, Mr. Schott merely alleges just temporal proximity, and this court's decisions in Trant and Vidaire explain that that's not enough. I would say, and it's also the fact that Mr. Schott received a credential every year until he left the Tribune, and even while he was at the Tribune was, publishing content that would arguably be critical of the legislature. He continued to receive a credential year over year.
Right, but here you have statements by the credentialing authority that he's been unethical and, he's no damn good any longer since he left the Tribune. I mean, isn't that raise a plausible inference of?
I would say no. So that incident that you're referring to in the text exchange with Ms. Peterson, that, as the district court explained in the transcript denying a TRO, that post-stated the revision of the policy, which occurred in November. That was in mid-December. So that could have no bearing on whether Mr. Schott then qualified under the criteria. He complains about the revision to fully exclude blogs and independent media, and the evolution of the policy over time shows that nothing was done here to target Mr. Schott. In 2021 and 2022, there was a loophole where bloggers or independent journalists could be qualified under some circumstances. In 23 and 2024, it was then narrowed to limited rare circumstances, and then it was then changed to close that loophole and not allow for it at all. And the reasons given for it is because there has been a large uptick in inquiries, and this is, it was explained in a declaration, but Mr. Schott cites this in the complaint. It's at paragraph 36 of the amended complaint that explains that the reason for this revision is because the legislative officials have been receiving increased inquiries from bloggers, independent media, social media, journalists, and they wanted to eliminate any sort of discretion and make a fine black and white line of who qualified and who did not.
I think your time's expired. And Mr. Miller, you have some rebuttal time.
Thank you.
Thank you.
All right, thank you, Your Honor. Just to clean up some of this factual stuff first. On page 15 of the brief, we cite to the parts of the deposition transcripts where they admit that there were no space constraints. We also made that allegation in the complaint. On page 17 of the brief, we have the long quotes from Mr. Schott explaining how he's injured by being excluded. It's not de minimis. With respect to Building Salt Lake, in paragraph 69 of the complaint, we state that the Building Salt Lake website described itself as locally owned independent media and touts that Building Salt Lake is a nationally recognized top 100 urban planning blog on the About page. It's probably been changed since then, but that's what it said at the time. So those are allegations that were there in the complaint. With respect to that, to the other people being excluded in 2025, the list that is on the complaint on page 92 of the appendix, that's a list that is from all 5 years, and they intentionally did not put dates on there. We asked them about it in the deposition, and on the deposition, it was asked if anyone from that list or anyone, if anyone other than Schott was excluded in 2025. And on page, appendix volume 4, page 28, they state that they do not remember anyone else being excluded in 2025, but they did ask more questions of Building Salt Lake.
How do we deal with that when we're on 12B6?
Well, with respect to 12B6, just look at the complaint, because we allege all these things in the complaint and the attached declaration. So it's all there for those purposes. I'm just clarifying that we were very careful about doing that. With respect to the argument that was being made that Mr. Schott can just go and get his sources elsewhere, copy off other media, or he can listen to the audio transcript, which, as you know from these things, are not always that good. With respect to that, going to other sources, in those opinions, they say unless there was content discrimination or viewpoint discrimination. When that occurs, there's no substitute that's okay. Even de minimis injury is a First Amendment injury that deserves to be rectified. We've requested that the court also order that there be an injunction put on. This is 2 years now that Mr. Schott has missed the general session. There are special sessions that are going to come up. We've established more than enough here to indicate that he was the only one that was excluded. He was excluded because of his viewpoint. And their statement that you just need to have a supervisor, someone who can fire you, just doesn't make sense. That doesn't even hold up as a rational basis for a policy. You only have First Amendment rights if we can go and jawbone your supervisor and they can discipline you. There's no government.
Is the General Assembly done for the day, for the year? Are they still in session?
They just completed their normal session.
And has there been any announced special session yet?
My understanding is there have been indications that there will be special sessions, but there's not been a timing of those that have been announced yet.
Right. So in effect, the request for injunctions really been mooted by the denial of the stay and the passage of time. And if there's another legislative session, I guess you can reapply.
No, Your Honor, because we're not. What we're requesting is that they be enjoined from denying Mr. Schott the credentials for these reasons. It's not letting him in, it's giving him the credentials. And a lot of times these special sessions are announced on very short order. And there's no reason to make us come back in emergency posture for this. We've tried this and it just takes too long. When a session is announced and they have it a couple days and then it's just gone. These are very ephemeral.
Okay. Yeah, I think we understand your argument.
Okay.
Your time's expired.
All right, appreciate it, thank you.
There was something I picked up on that at the governor's news conferences that the executive branch adopts the same list or whatsoever. Is that in the complaint or in a deposition or something else?
I think that, we have that in the complaint as well. We allege it there. So I think the governor's news conferences happen there, and they rely upon the legislative process.
My question is there anything in the complaint about that?
Yes.
Okay.
All right. Thank you.
Right, thank you, Counselor. You're excused. The case shall be submitted, and the court is in recess until tomorrow morning at 9 o'clock.